Hello, everyone. Thank you so much for joining us for Vermont Legal Aid's 30-minute town hall today. My name is Amelia Schlossberg, and I work at Vermont Legal Aid in the Office of the Healthcare Advocate. Vermont Legal Aid is a nonprofit law firm, and we help people across the state of Vermont with civil legal issues. Civil legal issues are things that are not criminal. So that includes things like housing, healthcare, disability law, elder law, tax law, family law, and again, things that aren't criminal law. So in this town hall series, we've talked about the stimulus check and tax law. We've talked about unemployment. We've talked about health insurance. And today we're going to talk about housing and renting during the pandemic. This town hall is going to be available after the recording, will be available on our Facebook page and also on our website. If you're joining us live on Zoom, you can ask us questions that I will share with our guests today. The questions can be typed into the Q&A box at the bottom of the Zoom screen. If you're joining us on Facebook, and we are broadcasting live to Facebook, you can ask your questions by typing in the comment section of the Facebook live stream. And if you're listening in over the phone, we don't have a way for you to ask questions during this, but if you don't hear your question answered and you still have questions afterwards, you can go to our website. That's www.vtlawhelp.org. And you can also call us if you don't find an answer on our website. The phone number is 1-800-889-2047. And I should note that the webpage, that's www.vtlawhelp.org, is updated constantly by Vermont Legal Aid and our partner organization, Legal Services Vermont. It's a joint project, and it's the best place to find updated legal information about the kinds of issues that we're talking about during these town halls. So check there first, and if you don't see an answer, you can always call, and Legal Services Vermont and Vermont Legal Aid will try to give you advice. So thank you everyone so much for joining us. Today, like I said, we're talking about housing and renting during a pandemic. My name is Amelia, and my guest today is Jean Murray. Thanks for joining us, Jean. Jean, you're gonna click your mute button. There we go.
Thanks, Amelia. I am Jean Murray. I am a staff attorney at Vermont Legal Aid in the Montpelier office, and I practice a lot of landlord-tenant law. Today we're going to talk, I'm going to give you a little outline of what we're going to talk about, and then what I hope to cover before we get to your questions, and then we're going to take questions. So what I hope to cover before we get to your questions is essentially evictions and what is the same as it's always been and what is different due to coronavirus. Where you can get help or what kind of help you can get at the moment with rental payments, and then other landlord-tenant relationship questions which have come up due to coronavirus.
Perfect. Thanks, Jean. And so if you do have questions on those broad topics, you can absolutely type them into the Q&A or use the Facebook chat. And if I can work them into this first 30-minute town hall, I will. And if not, we'll get to them afterwards when we do an extended Q&A after the first 30 minutes.
Okay, so the first thing I want to talk about so that we're all on the same page with what we're talking about, because the changes are going to be changes in process. So I want to talk about first a little primer on landlord-tenant law. Landlord-tenant relationships start with an agreement, and because of that agreement, the tenant takes possession of a rental unit, and then the tenant has possession and keeps possession either until they choose to leave or there's a court order to put them out. And in order to get a court order to put them out, that's a process we think of as eviction. So the steps in eviction, if the landlord wants you to leave and you didn't voluntarily move out, what the landlord needs to do is send a written letter saying the tenancy is terminated, and the letter has to say one of 4 reasons: for non-payment of rent, because the lease is at end, because you have breached the rules, the landlord-tenant law or your lease, or for no cause at all. And so the letter will say that, and then weeks or months later, if you haven't left, the landlord will have you served with a summons and complaint, which is the sheriff knocking on the door and handing you a big packet of papers. And then hopefully you will answer, which is make a written answer and send that to the court and the landlord, and then court process takes over. So that's the basic steps in landlord-tenant law.
So there are 4 ways that a landlord can get a tenant to leave through this legal process. And that's the general information. And one thing you didn't say, you didn't mention just like changing the locks. That's not.
We're not quite there yet.
Okay.
So, the changing the locks thing is, in Vermont, there is no such thing. It is illegal for a landlord to change the locks. The only way a landlord can get possession back is through a court order. The only way to get a court order is those steps I've just outlined. The 4 reasons: for non-payment of rent, for the end of the lease, for a breach of the lease, or for no cause at all. But those are the only 4 reasons. Well, I guess technically, if the landlord sells the building, they can send you a notice saying, "I've sold the building, please leave." Those are the only reasons that a landlord can get you out. And they need to do the paperwork, and then they need to let the court make a decision whether or not there's going to be a judgment for the landlord, and then a writ of possession. So in coronavirus days, what's the same? And I'm going to say it one more time: lockouts are illegal. The landlord can't change the locks. They can't shut off the water. They can't shut off the utilities. They can't take away your possessions. They can't do any of that in order to induce you to leave. That's all illegal. And what else is the same is if you get court papers, up through today, if you get court papers, you need to write a response and send it to the court, or you can be evicted by default without a hearing because you didn't respond. So if you get any sort of paper, if you get a notice to quit, that termination notice that I talked about, the written letter from the landlord, if you get that, or if you get court papers and you have questions, please call. Those are the kinds of things that we help people with all the time.
Got it. So Jean, we've got a question here just saying that if someone has a landlord is doing those kinds of things, changing the locks without this legal process, shutting off the water, taking possessions, things like that, if they're doing that, then they shouldn't be, and that's when we want to absolutely be there to support. And so reaching out to Vermont Legal Aid and Legal Services Vermont is really important in those situations.
Right. If you went to the grocery store and you came back and your apartment is locked up and you can't get in, you call us, but you can also call the police because they know that that is illegal also. So what's different now in coronavirus times, and what kinds of things have come down to help people stay in their homes? Well, we've been working very hard in the legislature, and the legislature has passed an eviction moratorium. We're only waiting for the governor's signature, and we expect to have it soon, maybe today. The moratorium is different than, you may have previously heard that the courts are closed. The courts, back on March 16th, quit scheduling hearings. So anything that required a hearing, they just took it off the schedule. And the courts plan to have no hearings, no non-emergency hearings until May 31st. The courts actually haven't been closed. They can receive papers, they can receive new complaints, they can rule on motions that don't have to have a hearing. And the one that concerns us the most there is a motion for default. If a court case got started and you got served with papers and you didn't file an answer, the landlord could move for a default judgment, and an eviction could happen without any kind of court hearing. So
Okay, so that's a big deal. If someone's getting eviction papers, that letter, the termination letter at the beginning, and then the paper later on, that they could end up going through a legal eviction process all the way to the end, where they're legally being evicted without ever setting foot in court if they have never responded.
if you don't respond, it is a big possibility that there could be a judgment against you. So if you received papers up to now, give us a call and have the papers in your hand and talk to the lawyer on the other end and tell them what you got, and they'll tell you where you are and what you can do to help yourself. So the eviction moratorium that hopefully is going to get signed today changes that a little bit, because what that says is even if court papers get filed, the court will take no action on them. The legal term is called a stay. All ejectment actions and all foreclosure actions that are filed once the bill is signed by the governor are stayed until the governor ends the state of emergency.
So it hasn't been signed yet on May 7th in the morning, but maybe if you're watching this later, we're really hoping, we were really working for this to be passed. And when it was passed, we were excited. And now we really are hoping that it will be signed, because it will make this change that's important for Vermont renters.
Yeah, yes. So I'm going to talk as if it is a law, because it's certainly been in the papers that it's been passed. And it may be a big assumption, and people can criticize me later, but assuming that this law is passed, is going to be law, especially if you're listening to this later.
So disclaimer, what Jean's about to say is speaking to the future, where we're really hoping this will be passed. So hopefully check our webpage, which will have that information as soon as it is signed, if it is signed.
Right, at 10:12 in the morning on May 7th, it's not yet the governor, so it's technically law, but when the governor signs it, this is what it will say. It will say the first thing I just said, that if an eviction or a foreclosure is filed, it is stayed as of the date of filing. Also in the law, it says that these cases won't be served by the sheriff. There'll be no sheriff service. The idea was that would be a social contact, and we wanted there to be no social contact. So cases could be filed, but they're stayed, paused the minute they're filed, and don't expect sheriff service. If there had been a writ of possession issued, the writs are stayed. If it's been issued and served, it's stayed, meaning it's not legally effective. And those will not be legally effective until the governor says the emergency is at an end. And then they have to be reserved, even if they've already been served. So,
okay. So we do have a question that's exactly this. So once the moratorium is over, what happens?
Well, it's hard to describe exactly how things are going to happen, because there will be a backlog. And so the courts are going to make some decisions about what happens first. Landlords are going to make some decisions about what might happen first. Sheriffs are going to make some decisions about what might happen first. But what the law contemplates is that the no cause and non-payment evictions that have been stayed will all continue to be stayed for 30 days after the governor ends the emergency. The ones for breach of lease and breaking the rules, those can proceed immediately when the governor ends the state of emergency. When I say immediately, immediately depends on how much resources the court will have to schedule those things. Because the court is going to institute practices that make sure that people are social distancing. And so what I imagine is they're going to slowly get to cases, not get to all of them on one day. So yeah, when the state of emergency ends, the writs of possession that have already been issued can be served or reserved. And cases that were stayed, if they're for breaking the rules or breaking your lease, can go forward. In cases that are for non-payment or no cause, we'll have to wait 30 days, and then those can go forward and be scheduled by the court.
Great. So the moratorium, there's a question, how long will the moratorium be for if it is signed? And so if it's signed, it will last through the end of the governor's emergency declaration. And for some people, it will also extend an additional 30 days before there's any movement forward on those evictions. And for other evictions, it will depend on the court's speed, exactly how things are prioritized and how hearings may be scheduled and how things may be moving forward after the emergency is over.
So one thing I want to mention is this law does not change a tenant's obligation to pay rent. This law, this moratorium, doesn't change a homeowner's obligation to pay their mortgage. If we can talk a little bit about mortgages because the rules for some of them are different, but this law doesn't make it so that tenants don't owe rent. They do. And if there's a rent into court order that already exists for some tenants, this law does not say they don't have to pay it. In other words, if you have a rent into court order, it needs to be paid. Amelia, should I talk a little bit about what might happen for some homeowners?
I think first we have a couple more sort of general questions about this moratorium, just briefly. So one question that came in from Facebook here is saying, so eviction proceedings that were filed before the governor signs, will they still go forward or will they also be paused during a moratorium?
That's a really good question. I appreciate that question. Everything that is pending now will also be stayed, not just new things. Everything that's pending now will be stayed. But if eviction proceedings have been filed, our advice is to file an answer. If you know that there's an eviction against you, you might as well file an answer. And if you need help figuring out how to file an answer or what you should say, call us. That's the kind of thing we help with.
And we would help with help figuring out how to file the answer. We would also help. There's a note here. Someone asked a question about extra paperwork you can file so you don't have to pay any court fees. So it would also help someone access that to make sure that they can file an answer and not have to pay court fees if they qualify for that.
You don't have to pay any filing fees for filing an answer. Now, to make things just so much more complicated, in 3 counties, there's now electronic filing. But if you are going to file, meaning mail something in paper to the court, you don't have to pay any fees for filing. If you're going to use electronic filing in those 3 counties, which is Orange, Windsor, and Windham, if you're going to do it electronically, there is a $5.50 fee to file. But you can file by mailing paper to the court, and that doesn't cost anything. That never costs anything. It costs something for plaintiffs, for people who are bringing cases. It doesn't cost anything for defendants who are answering.
So you're considered a defendant if you're answering a landlord's attempt to make you leave through this legal process. Okay, yes. There's one other quick question along this moratorium lines here. So are notifications from landlords to terminate, are those affected by a moratorium if it's signed?
No, landlords, well, many landlords can still send notices to quit. And the reason I smile is there is a federal exception. If your landlord's mortgage is backed by federal financing, Fannie Mae, Freddie Mae, USDA, rural housing, they should not be sending you a notice to quit until after July 24th. A lot of tenants don't know what kind of financing their landlord has, but I would advise landlords to check to see whether or not what kind of financing they have, because a notice to quit sent by a landlord that has federal financing could be considered ineffective. So it shouldn't be sent until after July 24th.
So the moratorium itself isn't stopping landlords from giving these notices to terminate, notices to quit, that initial letter saying we want you out for one of these 4 reasons. But if someone does have a federally backed mortgage on the apartment, that would prevent that from happening till July. Did you say July 24th?
July 24th. It should.
It should prevent that from happening.
Landlords who are paying federally backed mortgages shouldn't be sending notices of termination till July 24th. All the rest of the landlords can send notices of termination.
Right. So we're talking about what the law says things should happen. And we know, of course, that things don't always go by this. But this is what
that's what the law says should happen.
Got it. Okay. Okay, great. One last question on this moratorium before we move forward and get to this next piece. And then we'll have time to come back to more questions. But there's a question here. It says, is there a difference between the stay home order and the governor calling a state of emergency? Are they one and the same, or are they different? And I guess that's a good question, because we said the moratorium, if it's signed, would last to the end of the emergency. Is that the same as a stay home order?
So the governor declared a state of emergency in second week of March. And since then, he has written, as of yesterday, 13 addendums to it. I believe addendum number 6, or one of the earlier addendums, was the stay home, stay safe order. And that has been brought forward in every single addendum since then. And you may have heard that instead of closing all businesses and making everybody stay home, that the most recent one says that some businesses where there's not close contact can happen, and people can get together with trusted family and relatives. But the state of emergency that originally got declared, even though it's been amended as it got brought forward, is still in existence right now.
Okay.
Help?
So the emergency still goes on even if the stay home order ends. The stay home order is part of the emergency, but it's not the same thing as the emergency.
Right. If you read the addendum, the basic idea of mostly stay home is still there. It
right.
just is making some exceptions for being out and interacting with people if they're 6 feet away and wearing masks and things like that. But mostly it's still about stay home. In other words, if you read one of the last paragraphs in the addendum from yesterday, it says everybody's encouraged to stay home, work from home, do things remotely. It's still there.
Got it. Okay, so let's see if there's any more questions I want to make sure that you get to see it here before we move forward. If someone, let's see, and then we've got fantastic questions coming in here. And so far we've talked about the courts not being closed, but they're not scheduling new hearings. We've talked about the moratorium, and we've talked a little bit about this federally backed mortgage protection. There's a question here that says, how do you find out if your landlord has federally backed property?
There is no way other than to ask your landlord.
Okay.
There is no reliable way other than to ask your landlord. We're working, Yeah, there's a lot of there's a lot of things that are works in progress, a lot of ideas that are coming up, but now there is no way to know other than to ask your landlord.
It sounds like we would like there to be another way, but we don't have
I
one
would like
yet.
there to be another way, but there is
Okay.
none right now.
Thanks, Jean. And so just quickly, does the federal financing include PHA? So is that Public Housing Authority? Is that included in the federal financing?
Yeah, that's a very good question. I'm very glad you brought that up. So if you are in housing that because of the building that you're in, your rent is only 30% of your income or based on your income, you cannot be given a notice to quit for non-payment or no cause right now. So if you're in public housing, I think that's what they mean by PHA, Public Housing Authority. So yes, the federal moratorium on sending notices to quit applies for people who are in public housing. If you are got a rent subsidy, which is a voucher, a housing choice voucher, a Section 8 voucher, and you are using that to pay for an apartment that's owned by a private landlord, if the private landlord's mortgage is federally backed, then they can't send you a notice to quit. But the fact that you are subsidized doesn't mean your landlord can't send you a notice to quit.
Okay, so there are some protections. You had mentioned before there are 4 categories. There are some protections for folks living in a public housing authority space for 2 of those eviction processes, but not necessarily from the other 2. Okay, and so let's see. And just to reiterate, this information is on our webpage. I know we're covering a lot of things here, so definitely check our webpage to get more information about these topics. Okay, so we've talked a lot about evictions and some of the ways that the federal and state advocacies and changes are working to slow down evictions and give folks more time. Let's talk more about rent. I know a lot of folks are in a really difficult spot with rent right now.
So right now, and always has been, there is help with back rent and sometimes rental assistance for people who are very low income. And the way you access the current help that is available for low income Vermonters is to go to your local Housing Opportunities Program site. The way to find out where yours is to call 211. These are frequently administered through community action centers. So I would encourage people who are ending up with no income because of coronavirus. You're currently very low income, and call your local Housing Opportunity Program site and find that by calling 211. For the near future, there is federal relief money that is coming that Vermont could choose to spend on back rent relief for other people. Right now, there is one program on the table. It's not getting the biggest amount of funding. It's getting actually relatively small funding, but the Department of Housing and Community Development is working out a program for back rent. They're working on it right now. There isn't a way to tell you how to apply for it. You need to check the website, because once we know, we will let you know on the website how to apply for that money. But the other hope is that there will be more programs and a lot more money, relief money, that's coming to Vermont that is dedicated to back rent. It hasn't been decided yet, but we're advocating for it to be used for back rent for people who had a reduction of income because of the coronavirus.
So it sounds like the way to apply for the programs that are currently available would be through 211. It would be the place to start, would be calling 211, and that we are pushing for future, for federal funding to be made available to folks, for more people to be able to get this. But we don't know how that program is going to go. But when we do know, we'll put it on our webpage, and we also expect that 211 will be able to direct folks about that when it does happen. But we wish we don't have the details on it yet.
Yes, I'm concerned if people who can't be paying the rent because they can't afford it right now are holding off applying for programs because they hope that something will change and they'll be given relief in the future, and so they're not applying right now. I think people should apply if you have no income to pay the rent. One of the things that'll do is it'll signal state officials about how many people need this help. So if you have no income to pay your rent, please apply to the Housing Opportunities Program.
Thank you, Jean. And so I know that we're just at the end of our initial 30-minute town hall. I know we want to briefly touch on this other landlord-tenant relationship issues that can be happening during the pandemic. And then we have wonderful questions coming in from Facebook and from folks on Zoom. Really, really good questions we want to get to that we haven't gotten to yet. So just briefly, I know, Jean, we've been hearing from folks that are having issues around showing apartments and access to common areas or other kinds of in-person contact, things that feel more risky than they normally would when we're not in a pandemic.
Right, so under normal circumstances, in the landlord-tenant law, there's a section called access. And this says that landlords can have access to apartments for limited reasons: to inspect it when it's necessary, to do repairs, to show it to prospective renters or buyers. So that's in the normal case. A landlord can have access if they give the tenant 48 hours notice. But we're not in the normal case. So it becomes less reasonable to come into an apartment for any of those reasons, unless it's an emergency, like an emergency repair. Landlords can come in to prevent property damage and make an emergency repair. But other than that, because people are still needing to stay safe and stay home, that a landlord coming in for another reason is a close contact kind of work that is still prohibited by the executive order. So if your landlord says, I have to come in, and it's not because the ceiling is falling down or something, but just want to come in, I think tenants can say, that's not reasonable right now. It violates the executive order. Please don't come in.
Okay, I know we have some information about this on our webpage too, and it's just been coming up with folks that their landlords are showing their apartment and not necessarily doing it in a no contact way. So I think with that, we've covered the various federal and state attempts to slow down evictions and pause evictions. We've talked about some rent relief and some rent support for renters that is already in existence and that we're hoping will become available. Talked a little bit about some of these other landlord-tenant relationship issues during the pandemic. And now we've got, I see right now, 8 questions for Eugene. And so let's just get started on those. So the first one, is there a difference or an exemption for farm tenants where the rental unit is contingent on farm work? That is, they no longer have a job on the farm and the occupancy was contingent on being employed on the farm. Is there an eviction exemption or what's going on for those folks?
Well, there is a special farm worker eviction law. It's a separate process. I think if you Google Vermont Farmworker Eviction Law, you can find that there's a different process. I think, and you're testing me now, that the criteria is that the farmer needs to evict you because they need to have the housing for another worker.
So that might be different if they don't need the housing for another worker.
If they don't need the housing for another worker, I think it proceeds like a regular eviction.
Interesting. So it sounds like we're reaching the edges of stump the housing attorney.
Yes, you're reaching the edges of stump the housing attorney.
Okay.
I have the book here. I could look it up, but I think that's essentially it.
Okay, and it sounds like something we would want to look up if someone who was a farm worker was in that situation. That's the time when we would want someone to reach out.
Yes.
Great. Okay. All right. Next, stump the housing attorney question. Can landlords still increase, sorry, Jean, can landlords still increase rent to tenants during these times? Are there any restrictions on how much?
Yeah, unfortunately, there are not any restrictions on how much. What there is a restriction is how fast. So the landlord has to give, first of all, if you have a lease where for a period of time, it's agreed, the agreement is this apartment is $900 a month from June 1st till May 31st, the landlord can't increase the rent during that time because you have a lease or an agreement that that's what the rent is going to be for that year. So if there is no agreement or if there's no specified period of time, then the landlord can send notices of rent increase, but needs to send them 60 days before the rent increase is going to take place. So if rent day is usually the 1st, it has to be 60 days before the 1st. It can't be sending it on the 15th and then saying, hey, your rent is going to increase mid-month, even though you pay on the 1st. The second half of your month is going to be more expensive. So it's 60 days before rent day.
Okay.
The notice.
But right now there's no protections for how much that rent could go up.
No.
But there is protections, like we talked about earlier, just around the eviction process. If for some reason you weren't able to afford that rent, if there was an increase.
Yeah, if you kept paying your old rent and you didn't pay the increase, technically that's non-payment of rent, and the landlord could send you a termination notice for non-payment of rent.
Okay. This person is saying here, I have a lease that has been signed that is set to begin June 1. Yesterday, I suddenly lost my job due to the coronavirus, and I am now concerned that I will not be able to afford the lease that I agreed to. Oof. What are my options for possibly terminating the lease, altering the lease, or getting the deposit I put down back? Well, that's a tough situation. Sorry about the job loss.
Well, it really depends on your landlord. That's the first thing to do is talk to the landlord. Say, this is what's happening. Can I have my deposit back? I can't move in June 1st. It being pretty early in May, I think the landlord has the option of saying, I will try to find another tenant by June 1st, but it may take me longer than that. And you may be legally on the hook to pay, but the landlord has a duty to try to find another tenant if you have to break a lease because you can't perform on it. So talk to your landlord as soon as you can, and hopefully the landlord can re-rent it to someone else by June 1st and give you your money back, because that's what should happen.
Okay, and so that's what should happen. Jean, a follow-up question: if a landlord says no, we don't want to try and re-rent it, is that something that they can say, or you're saying that there's a requirement for them to try to re-rent it?
There's a requirement for them to try to re-rent it. So example, if they just say, okay, well, I'm going to leave the apartment vacant and sue you for all of the rent, and they cannot show that they tried to re-rent it, they are not going to be successful in their lawsuit.
Got it. Okay. Thank you, Jean. So next question here. If mortgage relief is in place for landlords, will rent forgiveness to tenants be a requirement?
No. I think I understand the question to say, so let's talk a little bit about what mortgage relief is. Mortgage relief, first of all, applies to single-family homeowners, and there's a lot of them in Vermont, and they don't necessarily have a lot of money. So if your mortgage is federally backed, and you were somewhere in the eviction process, that was stayed between March 18th and May 16th. So there should be no new case filed or nothing moved forward on a case that was filed. In addition to that, people who have federally backed mortgages are entitled to apply for what's called a forbearance. which means that they don't have to pay now, and the payments they would be paying now get tacked onto the end of the loan. And so it's not like they don't have to pay. It's just that when they have to pay gets put off. And that moratorium for federally backed mortgages, that forbearance piece, comes without having to pay interest or penalties to the homeowner. So it's just extending the life of the loan. Although it also has provision for the homeowner to get together with the lender and maybe modify the loan in some way, form, or other. But that's what a forbearance is. So that didn't come with provision for if you're a landlord with a federally backed mortgage and you don't have to pay your payments for, however long your forbearance is going to go, that the landlord must forgive the rent. Because, not that I understand exactly everything they do in Washington, D.C., but the thinking is the homeowner that's paying the mortgage is going to have to pay the mortgage. So they're not being forgiven mortgage payments. They're just putting them off down the road.
So right now, there's this two pieces of this question. There's mortgage relief, and then there's rent forgiveness. So mortgage relief means they're delaying the mortgage. They're not actually forgiving any of it. And rent relief suggests that the rent would be forgiven or not owed at all. And none of the programs we've been talking about are rent forgiveness, but we're hoping for federal programs that will be rent relief and will help people pay rent.
Yes, we're hoping for programs where a tenant can apply saying, I haven't been able to pay the rent, give me money so that I can pay my landlord the rent.
Okay, and that's different from any requirement for rent forgiveness, which currently wasn't included in any of those laws.
There is none that I know of. Although if you are in subsidized housing and your income has gone down, so you can't be paying your portion of the rent, you should immediately tell your subsidized housing providers, your property manager, hey, I have a reduction in income. Because if your income is reduced, subsidized housing providers can refigure your rent amount, and the subsidy can pay more and you can pay less. I think that would apply for Section 8 and housing choice vouchers too. So if you have a reduction in income, get a hold of your housing authority and say, my income has gone down, reduce my rent. So that's not exactly rent forgiveness, but it is a reduction in rent for people who have subsidies.
Got it. So long story short, rent's not being forgiven. It just it might change who's actually paying it. Maybe the federal government might help pay it, or the program that you're already in for help paying rent might help pay more of it.
Yes.
Great. Okay. Great meeting. I understand you, not necessarily if that's good or bad. So another really good question here. You've got really fantastic questions all throughout this entire thing. So what should you do if a landlord is threatening the tenant or contacting the tenant saying inappropriate or unprofessional things after eviction paperwork have been served? Is this considered harassment?
Well, legal harassment. So this is, it sounds harassing to me. Yes, that doesn't sound very nice. Constantly calling or bugging or whatever is not a good thing. If it ends up containing threats of violence or a reason to fear for harm, it could be, you might be able to get an anti-stalking order, but it's got to contain threats of harm. Calling every day and, being called names, it's very unfortunate and it should not be allowed. And it could give rise to a counterclaim in an eviction of intentional infliction of emotional distress. So it's not okay for landlords to behave that way.
But in terms of legal arguments to make them stop, sounds like we might have some, but we might also not have others.
Right. It depends on the degree to which what's being said exactly.
Okay. And is that something that Legal Aid gives advice around? Is that something you might be able to find out more information about on our webpage?
I think so. We have quite extensive landlord-tenant web pages. And certainly if the reason or the content of what you're being harassed about is something that is protected by fair housing law, then definitely it's actionable. So if they're racial slurs um, or slurs based on age or
You have kids, something. Yeah.
gender or having kids or receiving public assistance, all of those are violation of both, some of them are federal and some of them are Vermont bases for
Yeah, state and federal.
fair housing.
Okay, thank you. Let's see, we have a suggestion here from someone saying that if you are getting harassment, to try and record it in order to use it as proof in court if you end up going to court. Is that a good suggestion, to try and record any harassment if you do end up taking some legal action?
There's certainly no technical prohibition against recording it. It's a tricky thing to do, not to make the recording, but to make a recording without somehow participating or urging on an argument, so it could backfire. But
Okay.
if you have heard things, I would completely urge people to just get a notebook and make a note of what got said to them, when it got said, how, just make a note of it, because you can testify to what somebody else said to you.
Okay, so that's the kind of thing you look for if you were an attorney that was helping someone with a harassment situation in a landlord-tenant issue. I know that we do have attorneys that specialize at legal aid in supporting folks that have experienced harassment and violence and threats like this. A lot of those experiences that we work with are folks experiencing intimate partner violence within a family or within an intimate partner, but it sounds like some of the similar arguments, similar ways we make those arguments to protect people would apply to if someone has an abusive or harassing landlord. So our webpage should have information about that, and we should be able to be a resource in some of those situations too.
Hey, I want to correct myself because I think I could be misinterpreted. I said, you can testify to what somebody said to you.
Okay.
That somebody is the person who is the opposing party in your lawsuit.
Got it.
Sorry about that.
Thanks, Jean. Okay, so let's see, next question here. So are state required inspections where someone needs to enter a unit, like a sprinkler inspection or an HVAC inspection, are those also on hold during the governor's executive order?
Yeah, stump the housing lawyer.
Okay, so we don't know the answer necessarily, or?
I would imagine that state agencies are following the executive order and not doing things that require close contact. So I don't know official statements about whether or not the Department of Public Safety or town health officers are conducting inspections.
Like how they're navigating that. Okay. Let's see, one more question here. We've got a bunch more questions coming in. These look fantastic. So you mentioned earlier about termination of lease notice because of a sale of building. It's person saying those are time limited to point of sale. Are the time limits going to be extended, or are new buyers expected to send notice within the time limit? And I have to admit, I don't know what that question means because I don't have any housing law background.
So it depends. So in order for me to answer the question, I would need to understand your facts better.
Okay.
But if a homeowner is, or an apartment owner, you're renting an apartment that's being sold, the landlord can send you that letter saying your tenancy is terminated because I am selling the building. That's what it says. How the landlord can later prove, if you have to go to court to prove you should get out of the building because it's being sold, how the landlord goes about proving that, what stage of the sale, what's required to prove that there's a sale, is another matter entirely. Does that make sense?
That does make sense. And it sounds like there's a time limited issue. And so during the pandemic, there may be some of those sales may not be moving forward. And I think maybe part of the question is about that. So I guess the answer is if someone's if you're living in a place that is being sold, check our webpage for more information. And if it looks like you're going to need to leave and you don't want to leave and you can't find somewhere else, then we would want to try and help you.
Right. So let's say the landlord has signed a purchase and sale agreement closing in 90 days. And so they send you a 30-day notice to quit and you don't leave. They want to close 60 days from now. They would need to file a case in court. Cases in court are going to be stayed. They are not going to be able to get an order for you to leave. If the buyer is only going to buy a vacant building and may object to the closing, then the landlord isn't going to sell, I guess. But maybe the buyer would agree to go ahead and close, and then the buyer would need to start a no-cause eviction.
Got it. Thanks, Jean. Okay,
Yeah.
thank you. So another question here, if someone is living in an RV on someone's property and paying rent to the homeowner for the past year, how do they evict that person, or can they during this time? There's no signed lease. This is interesting. Question asking, how can someone evict someone else?
Whose RV is it?
It's the RV of the person that's trying to evict someone, I think. Actually, I don't know. They didn't say.
Yeah, we don't know.
We don't know.
Need more facts to know how to answer that.
We need more facts, and Vermont legal aid doesn't usually help people evict other people. Right? Or that's.
I guess one thing to say is that if the person who owns the home or owns the yard or whatever is a vulnerable adult, and they feel like they are being harmed, exploited in some way by the person living in their yard or living in their attic or living in their basement, they can call legal aid and figure out how to get help with that situation.
Okay, so we generally would not be helping someone evict someone else, but we would help if someone is a vulnerable Vermonter that is feeling exploited or at increased risk or something like that. We might be able to give some advice. I did get some clarity here, the person saying that the RV belongs to the person who is in sort of like the renter-like position, not the person who owns the house. Does that give us any quick answer, or we still have more questions before we want to try and help the person?
So the person who wants to evict someone else would have to follow the landlord-tenant law.
Okay, even if there's no signed lease?
Yeah, of course, even if there's no signed lease. There's no requirement of a signed lease in order to have a valid tenancy and a rental agreement. Rental agreements can be oral or written. So,
okay.
Yeah.
Okay, thanks, Jean. Let's see. We've got some people who are sharing some information about, they've heard that inspections are only happening on vacant properties. Do we know if that's true? It sounds like that's possible.
There's all sorts of, first of all, there are inspections by state and local agencies, and there are also inspections from public housing authorities who are inspecting properties that would be rented so that they can lease up to make sure that the property, the units meet housing quality standards. And so I think that you're certainly not in any, nobody's in any trouble if the inspection is of a vacant property. That doesn't violate stay home, stay safe. But to say to come in for an inspection when you have 2 kids at home and a small apartment, I think maybe that it could be put off.
Okay, yeah, we've got other people giving more information about public housing authorities only inspecting vacant units, and VSHA. What is VSHA?
Vermont State Housing Authority.
Okay, and so it sounds like inspections through Vermont State Housing Authority maybe are only in empty unoccupied units as well, potentially. That's some information coming in from Facebook, so we haven't vetted it, but.
Yeah, Vermont State Housing Authority has a web page. Just Google Vermont State Housing Authority, and I think they, like a lot of agencies, also have their COVID-19 section that says what it is that's changed during the pandemic.
Got it. Okay. And then Jean, I know we've had participation, folks asking questions from Burlington Tenants Union today. And is there any information we have around folks' rights around unions or any of that we want to give out around renters?
So Vermont Legal Aid has always supported tenants and renters' rights. And we know that many Vermonters are struggling right now. We support renters' rights to organize a tenants union and believe that ensuring tenants' voices are heard is a really important thing at this time. Vermont law prohibits evictions that are retaliatory because a tenant has joined a tenants union. However, tenants can be evicted for not paying the rent. Vermont Legal Aid is in the legislature and working with the administration to encourage them to institute payments for rent that can't be paid by renters during the pandemic. Because of the coronavirus, Vermont has received $1.25 billion to help Vermont and its citizens. Vermont Legal Aid is advocating that money be spent on rent payment relief so that no one loses their home because of the pandemic. We ask that Vermonters join us in our efforts in advocating for payment relief to come out of the coronavirus relief funds.
Thank you, Jean. So joining a tenants union is not something that that someone could be retaliated against with an eviction. That's not on the list of 4 or 5 reasons. And so that kind of organizing is really important. Okay, we've got a couple last questions. I know we're almost out of time here. Let's see, this person says, folks who are in hotels due to experiencing homelessness and they're placed and paid for by the state, when the governor's order is lifted, will they have to be in an eviction process to get them to vacate that hotel?
I blanked a second. So they're
okay.
Who are they?
I know that Vermont Legal Aid is really worried about Vermonters that have been experiencing homeless that are now housed in hotels during the pandemic. And so when the emergency order ends, we've only got a couple minutes left. So this is I know something that is very much one of Legal Aid's priorities right now. What can folks that are homeless and currently housed in a hotel expect around eviction and the protections that may be available to them?
So we have heard that Vermont's Agency of Human Services, which is the one that has secured motel rooms for people who were homeless in shelters and without a home, they are going to continue to house the people in motels until they can transition them and bridge them to permanent housing. Now, I'm not sure whether or not that means they get to keep the same room, but Agency of Human Services, Office of Economic Opportunity, and lots of agencies, local mental health agencies and pathways, and a lot of people are working at trying to make that population as stably housed and comfortable as they can during this time. So no, there's not going to be an immediate, everybody gets kicked out of hotels when the emergency ends, if the emergency is declared at an end.
And would the regular eviction rules apply, or might it be different for those folks?
It's going to be different.
Okay. And so if someone's in those situations looking for help, it sounds like this is a priority population for Vermont Legal Aid to be reaching to. So keeping an eye on our webpage
Yes.
sounds like as important as those things change. Okay, we've got just 2 minutes left. This has been a fantastic town hall on housing. Definitely not as uplifting as some of the good news we were able to give out in some of the other town halls. Housing is really difficult. And I really appreciate, Jean, your answers today. And I'm really happy to be able to end on this note here. This is a question I've been hearing a lot, and someone just asked it right now. So how do we help in this effort to help renters who are struggling right now? Jean, you had said in your answer before around organizing that Legal Aid is really working really hard to get more support for renters. How can folks help in that effort?
I think you, as an individual, you can contact your legislator, you can contact state officials, you can contact the governor and say, hi, I don't have enough money to pay the rent because of coronavirus. And let people know that the need is out there. The legislature is going to appropriate money, appropriate the $1.25 billion. Some of that's already been spent, but there's plenty left. And part of it can go to helping individual Vermonters pay their rent. And so getting that message to legislators and the governor's office is pretty important.
Thank you. Okay, thank you everyone so much for being with us today. I really appreciate everyone who's been participating by Zoom and asking questions and listening, everyone who's been joining us through Facebook Live, everyone who's been listening in, and folks that will be listening to this recording later. Thank you so much. I do want to remind everyone that there's that www.vtlawhelp.org. We've got lots of information. That is a joint project between Legal Services Vermont and Vermont Legal Aid, and we're keeping it updated every day as new information comes in. There are a lot of changes coming quickly as we hope that these programs get rolled out. We'll put the information there. We weren't able to get to absolutely everyone's questions, but we answered more than 40 of them. And I really appreciate everyone. You can join us next week, Thursday at 10 a.m. The topic will be consumer issues, and that means that we'll be talking about debt and problems paying bills. So that's what we're talking about next week. Thank you again, everyone, for joining us. Thank you, Jean, so much for answering questions today. I really appreciate your time and your expertise and your experience both as a housing attorney and as a renter.
Yeah, yes, and thank you, Amelia.
Thanks.